Welcome all. This is going to be the first of a handful of videos that will help prepare you for the types of things that you're going to need to do during the mock trial. So we'll start off with some really basic stuff concerning the mock trial, and probably get into opening statements with this video. Future videos will take a look at the direct examination, cross-examination, closing statements, raising objections, things like that. So this might be a couple videos, but I'll try to keep them short. Try to keep them as like short tutorials. Okay, so we'll start off by just some basic definitions when we talk about the parties that are involved. The people who bring their argument to the trial are called the parties to the case. So in a civil trial, this involves one person, the plaintiff, complaining about something another person, the defendant, did or failed to do. In a criminal trial, one person, the defendant, is accused by another person, the prosecutor, who is actually representing us, the people, or the state. They're accused by another person of committing a crime. So, as I said, the prosecutor represents the state, which represents the people. Okay? So, when it comes to the facts of the case, so long before a trial actually takes place, some argument or some incident occurs. This argument or incident involves many facts which together make up the case. So persons on opposite side of the case often will view the facts quite differently. And this disagreement over the facts of an incident or an event forms the basis of a trial. If you remember, our system is a system of criminal justice. So we have two sides presenting two different cases or two different interpretations of the facts of a case, and it's left up to a trier of fact, which in most cases is the jury, to render a verdict, basically to decide whether the person is, the defendant is guilty or not guilty. So essentially, they decide which side they believe the most, right? So what makes up evidence? What is evidence, right? So attorneys for each side will present all of the factual information that they can gather to support their side of the case. So this information that they gather is called evidence, and it can include testimony from witnesses, and eyewitnesses, and expert witnesses, we see. And it can include documents, it can include physical evidence, such as a weapon, a murder weapon, or credit cards, or a cell phone, or any type of physical evidence. And as we said, it could also include expert testimony. So evidence comes in lots of different forms. We'll see how exactly you enter items into evidence in a courtroom. There's a procedure for doing that. It's simple, but we'll discuss it. In terms of burden of proof, so what do the jurors need to meet in terms of their confidence when rendering a verdict? Well, for civil cases, plaintiffs must convince the judge or the jury by a preponderance of the evidence. This just means a majority of the evidence favors this side versus the other side. So it could be literally 51% in favor of the plaintiff, 49% in favor of the defendant, and the plaintiff would win the case. So the preponderance of the evidence is just whoever has the most compelling case. Not much to it. Could be razor thin. For criminal cases, the burden of proof is much higher. So the prosecution must convince the judge or jury, usually a jury, beyond a reasonable doubt that the defendant has committed a crime. So when we refer to beyond a reasonable doubt, we could often think of this in terms of our alpha level that we use when we reject a null hypothesis. So beyond a reasonable doubt is considered about 95% confidence. So it's not beyond all doubt. That would be impossible, but beyond a reasonable doubt. So you gotta be pretty darn sure before you convict somebody or find them guilty. Okay, so the order of a trial, what actually happens, and the sequence of events that occur. So the trial begins with the prosecution making an opening statement, and we'll see what opening statements are all about in a little bit in the next part of this video here. But the prosecution will start with an opening statement, then the defense will make its opening statement. This is followed by testimony from witnesses. So the prosecution will call their witnesses first. So the prosecution goes first, right? They're the ones, that's the side that has something to prove. So they will present their case, and then the defense will have an opportunity to present its case and to rebut some of the things that the prosecution raised during its case. So we'll have start off with the direct examination of the first prosecution witness. So the prosecution will call their first witness and question them, and the questions are designed to elicit the facts of the case. So we'll have a whole segment on direct examination and cross-examination. So for now, we'll just focus on the trial order. So there will be the direct examination of a prosecution witness, and then the defense will have an opportunity to cross-examine that prosecution witness. Now, the cross-examination process is designed to kind of delegitimize what that witness said during the direct examination, but we'll also talk in depth about how to do effective cross-examination. This can be followed by a redirect examination of the prosecution witness. So if something comes up during cross-examination, the prosecution might want to clarify something by asking a question or two of their witness, and if during that redirect, if some new information comes up, then the defense would have an opportunity for a recross examination of the prosecution witness. So this process of direct examination, cross-examination, redirect, and recross examination will apply for every one of the prosecution's witnesses. So steps, say A through D, will take place for each prosecution witness, and then once all the witnesses have been called for the prosecution will rest its case. Now it's time for the defense to present its case, and it will start with calling its first witness and doing a direct examination of their first witness. That'll be followed by the prosecution cross-examining that first witness. There might be a redirect examination of that defense witness by the defense attorney, and there might be a cross examination of that defense witness. And that process is going to continue for all of the defense's witnesses. At which point, when there's no more defense witnesses, the defense will rest its case. After that, the prosecution may call, they don't have to, but sometimes they will call a rebuttal witness. A rebuttal witness is a witness that is called to refute some testimony or some evidence that was brought up during the defense's case. So if the defense called in an expert witness during its case while it was presenting its witnesses, now's the time for the defense to bring in their own expert witness to refute the testimony that was given by the defense's expert witness. The defense can then call a rebuttal witness to the prosecution's rebuttal witness, and there would be direct and cross-examination of both of those rebuttal witnesses as well. And it could be more than one rebuttal witness, but we're not going to have to worry about that for our mock trial. So once all the witnesses are done, all the direct and cross-examination is done, next will come closing arguments, and the prosecution will start with closing arguments, and we'll have a video describing what should go into a closing argument, what makes a good closing argument, and then the defense will have its closing argument, and if the defense brings up certain information that wasn't previously mentioned, then the prosecution might have a rebuttal argument, a rebuttal closing argument. But that's not likely to happen for our mock trial. So for closing arguments, the prosecution will go first, then the defense. After that, the trial is over as far as what's happening inside the courtroom. All the action moves to the juror room where deliberations are going to take place. So the final step would be jury deliberations, where jurors will go through the different evidence that was presented, discuss it, and go through the judge's instructions that were given to them, go through the different charges and legal definitions of the charges, and ultimately reach a verdict for each of the charges that the defendant was indicted on. So this is just a diagram of a typical courtroom, how the layout is set up. We're not going to have to worry about this for this semester, but typically you would have the prosecution table over here and the defense over here. So the defendant and his or her lawyers would be sitting here, and the prosecution lawyers would be sitting at this table. The jury of 12 members would be sitting over here in the jury box. You can see this is the judge's bench here, and to the left of the judge's bench is the witness stand. So witnesses would be called up, come up to the witness stand. you can see that there's also space here for the court clerk and the court reporter. I'm basically going to be taking a transcript of everything that's happening during the trial. This is spectator seating, so people can go into court. Pretty much every court is open to the public, so you can go to court and sit in and watch if you wish. This area between the judge's bench and the prosecution and the defense, this area here is called the well, and nobody is allowed in this area unless they ask for and receive permission from the judge. So all of those TV shows that you see where, you know, the prosecution walks up to the witness on the stand and leans up against the witness, or bangs their hand on the railing of the witness stand, that would not happen. So when you ask questions, you stand up when it's your turn to question a witness. You just stand up at your seat at this table and you ask the questions. Sometimes there's a podium that is placed here that an attorney who's asking questions, doing direct or cross-examination, instead of just standing up and asking questions at the table, they might walk over to the podium and ask their questions. You could only approach the witness if you ask the judge, and if the judge gives you permission to do so. Otherwise, you do not go inside this well. It's like sacred judge space there. Okay, let me load up the slides for opening statements. Okay, so we're back, and we'll talk about opening statements here. So this is how the trial begins, with the prosecution making an opening statement, followed by the defense making an opening statement. So what's the purpose of the opening statements? Well, they serve as an introduction to the case. They're basically designed, if you do them correctly, as a way of kind of setting up your story, right? If you're taking a story model approach to jury decision making, this is your introduction. Basically, you're going to include a summary of the facts according to each party. So you're essentially going to say the prosecution, or say I'm the prosecutor, I'm going to say, this is what happened. The defendant did this, the defendant did that, right? And the defense is going to say that the defendant didn't do this and they didn't do that, but we have the evidence, so on and so forth, right? So we have a summary of the facts according to each party, a summary of the evidence that will be presented to support the facts. So we're going to say this person was killed. The defendant killed this person, and we have the fingerprints and the DNA and the this and the that to prove it. Also, we want to include in the opening statement or opening argument a statement regarding what the party hopes to get out of the trial. So if you're the prosecution, you should end your opening statement with, we hope that you will do the right thing and return a guilty verdict, or something along those lines. We hope that you will make sure that justice is served and return a guilty verdict. If you're the defendant or the defense attorney, you would say the opposite, right? But pretty much along the same lines, that We hope that this jury will do the right thing and find the defendant. You wouldn't call him the defendant. You would say, find my client not guilty, right? So essentially you want to end your opening statement with what you hope the jury will do, what you hope to get out of the case. So if the jurors heard the opening statement and nothing else, would they understand what the case is about, and would they want to decide in your favor? That's essentially two questions that your opening statement should answer, right? Or should be able to answer. So if they heard nothing but your opening statement, would they know what this case is about, and would they want to side with you, and not the other side? So keep those two questions in mind when formulating an opening statement. So when it comes to the prosecution or the plaintiff in our case, it's going to be the prosecution. We're dealing with a criminal case here. So the opening statement for the prosecution and the opening statement for the defense might be a little different. They might have different goals or different intentions, or different information even that they want to convey. So for the prosecution or the plaintiff, the general purpose is to explain the steps that are involved in the trial. So inform the jury, this is what's going to happen. You're going to hear from this person. Then the defense is going to ask this person questions. And then you're going to hear from this next person. And when all of our witnesses are questioned, then the defense is going to call their witnesses, so on and so forth. So explain the different steps that are involved in the trial. You also want to outline the charges or the complaints that are against the defendant. If it's a murder case, explain what that means, right? Especially if we're talking about premeditation or premeditated murder. And explain to the jury what premeditation actually means. What is this defendant really being charged with, right? Try to convey that to the jury. You also want to outline briefly the case that's going to be presented. So give an outline of what you're going to show, what you're going to prove to the jury, right? So you're going to say the evidence will show that the defendant was at this place at this time and that he killed that person, right? So outline your case, including your major, basically what the evidence is going to show. It's important to create a positive first impression. You only get one chance to make a first impression, so put on a good show and rehearse this opening statement. Don't have too much pressure on you, because that might make you anxious, but be confident in terms of speaking to the jury, and since we're doing this remotely, you're gonna want to make sure that you're looking into the camera when you're making this statement. You also want to acquaint the jury with something personal about the case that's favorable to your side. So a common tactic is to create sympathy for the victim or for the victim's family. So you want to kind of, in your opening statement, play up the the pain and suffering that the victim or the victim's family or loved ones is going through. And you also want to try to depersonalize or dehumanize, in a sense, the defendant. So the prosecution should refer to the defendant as the defendant, not by his or her name. You want to try to make the defendant a non-person as much as possible, right? So the way that you refer to them should be really impersonal, to the extent where you're almost depersonalizing them. Also, the prosecution should try to downplay the burden of proof. So, you might do that as a prosecutor by emphasizing that it's, reasonable doubt. Beyond reasonable doubt doesn't mean beyond any doubt. That it's important to make sure that justice is served here. And we want to be accurate, but there's doubt. There will always be doubt. There's doubt associated with everything. What's important is that we have justice for this victim who was killed. Something along those lines, right? You kind of want to play down that burden of proof there, and get the jury to try to focus on some other aspects. So what does the defense want to do? Well, the defense, first and foremost, wants to cast the jury's role in terms of involving basic principles of American justice. Essentially, the defense wants to instill in the jury that it is up to them to uphold these civil rights that we have, right? That the Bill of Rights are in their hands, essentially. So part of that is to make sure that the jury understands that just because someone is indicted or that they're accused of the crime, or accused of a crime, that does not mean that they're guilty. That's not evidence of guilt just because someone is accused of a crime. Also to emphasize that there's a presumption of innocence, that a defendant is innocent until proven guilty, and that burden of proof is beyond reasonable doubt, and the defense should really stress that, and also discuss what reasonable doubt means, how it is a very difficult standard to reach, and it's up to the prosecution to prove beyond a reasonable doubt. You also want to talk about the effect of circumstantial evidence, and we'll talk about that a little later, maybe in a different video. So something else that the defense will want to do in its opening statement is to outline the case that it's going to present. So give a summary of the evidence that will be presented through your witnesses, what the evidence is going to show that your client, that the defendant, is not guilty. Also, you want to make sure that you create a positive first impression, and here you want to do the opposite of what the prosecution is trying to do. The defendant, the prosecution, is trying to dehumanize them or depersonalize them. You want to humanize the defendant, call them by their first name, or maybe even by their nickname if they have a nickname, right? You might want to, in that opening statement, talk about their kids, right? Or how much they love their dogs or something like that. How much charity they do. Something that's going to make them look like a good person in the eyes of the jury. So the opening statement for the defense should try to humanize the defendant somewhat. So when it comes to some basic rules of the trial, you need to stand when you address the court. So you need to stand whenever you address the judge. But because we're doing this remotely, we won't require people to stand to address the judge, but will still have to refer to the judge, me, as your honor, right? So anytime you address the judge, it should be your honor. You never want to talk directly to the opposing attorney. So any communication has to go through the judge. So if you don't talk to the other attorneys at all, the other side. Any communication would go to the judge, and the judge would pass that information on or tell you to no, forget it, we're moving on. But don't talk directly to the opposing attorney. You want to direct your comments only to the jury, or you direct your comments to the jury only in your opening and closing statements. So that's the only time that you are actually going to be addressing the jury and talking to the jury. The rest of the trial, you are going to be questioning witnesses. So outside of opening and closing statements, don't talk about the jury, don't talk to the jury, don't address them in any way. You want to make sure that you paint a clear picture of your case. Again, a clear picture of your story. That's essentially what you're laying out here, right? So be clear, try to keep it simple, keep the questions simple, keep the line of questioning simple. You'll see, particularly for direct and cross-examination, there's different types of questioning that you want to do. You need to avoid leading questions when you're doing direct examination, and you kind of want to use leading questions when you do cross-examination, but we'll get to that in another video. You also want to use proper tense during your opening statement. You'll say, this is what we are going to show, right? The evidence will show this. In your closing statement, you'll say the evidence showed, the witnesses testified. It would be all past tense for your closing statements. But we're focusing on opening statements here, so make sure you're using the future tense, right? Key rule for anything in life, not just this mock trial. Never promise what you can't prove. So don't say that, we will show that the defendant is not guilty, right? We will prove that the defendant is not guilty. Don't say that, right? You could say the evidence will show that the defendant could not have possibly committed this crime, right? That the defendant was nowhere near the location where this crime was committed. Whatever the evidence is going to show. And then you could ask the jury at the end, we hope that you will return a verdict of not guilty. We hope that you will do the right thing and find my client not guilty, right? But be very careful that word prove, right? Always appear confident, even if you're not confident, and it's going to be a little strange, right? This is the first time that I'm assuming the first time that all of you are doing this, but do your best. You'll have notes there to help you along. So fake it till you make it, right? Just the appearance of confidence can go a long way. Some do's and don'ts. Be aware of your posture. So as attorneys, especially when you're speaking to the jury, you want to make sure that you're standing up straight or sitting up straight, and that you're not slouched over. Also, when it comes to your voice, make sure that you're speaking very clearly and that you have a conversational tone to your voice. You want to be speaking with the jury, so to speak, right? Speaking to them as if you're having a conversation, not as if you're giving them instructions or giving them a lecture or anything like that. Also, avoid jargon or slang or figures of speech. Not everyone knows what slang words mean. Jargon is just technical terms that, again, not everyone's going to know what you mean. And figures of speech, these types of sayings, sometimes people don't understand them, or they think they mean something else, right? So they might misinterpret that figure of speech, or they just might not get it. They think you're saying something different than what you're actually saying. You want to use a variety of body language in your delivery. So, we could just summarize that as try not to be robotic. Make sure you move around. Move your hands around a little bit when you're talking. Do some stuff with your head. Make sure that you look like you're, a human, especially because we're doing this remotely. It could very easily come off as being really rigid. It's something, that I don't think I have much of a problem with, because I have ADD legit, so I'm always moving around in my seat. But that's something that you should be cognizant of, is to make sure that you're using appropriate types of body language. For your opening statement and closing statement, you want to try to memorize the statement, or at least memorize the key points of the statement. You don't want to read off of a prepared script. It's just not gonna come across as natural. You could have bullet points, or you could have the script in front of you, and you could refer to it, but you should definitely practice the opening statement. This is your first impression to the jury, so it's important. It's an important opportunity to make a first impression, right? So definitely prepare for it. You want to avoid arguments in the opening statement, so you don't want to start arguing the case. We'll talk about what arguments actually mean. We're not talking fighting here, but we're talking about actually arguing a point, making a case, or making an argument for a particular point or a particular fact. You don't want to do that. That's what the trial is for. Also, during opening and closing statements, objections are not allowed. So when the other side is making their opening statement and you don't like something that they said, tough shit, right? You don't get to object during opening statements. Okay, so we'll take let's just make sure this video plays. Okay, so we'll take a look at this is basically a setup of a crime, some background information that you will need in order to see or to fully appreciate the opening statement that's going to come from this. So just watch this first, and then we'll show you an opening statement that's based on this case, an actual opening statement based on this case.
I'm Peter Van Sant, correspondent for 48 Hours, and welcome to my office. A lot of people think we spend lots of time here, but in fact, most of my time is spent on the road.
This is where Leslie was standing when the photo was taken.
While 48 Hours will follow a trial for weeks at a time,
People of the state of Colorado versus Frederick Mueller.
I always want to get to the scene,
You can hear the creek in the distance. We're getting closer and
especially in
closer.
a story like this, where the accused says his wife fell off a cliff.
A little treacherous here, isn't it? Yeah.
This is the beautiful mountain community of Lake City, Colorado. Lots of wealthy Texans have summer homes here. We hiked along the exact spot where Fred and Leslie Mueller were when tragedy struck.
One step and you're over the edge here. Fred was there. These glasses were found way up here.
While spectacular, this is wild country. And the creek can be quite treacherous for our camera crew. So 48 Hours took to the air, hiring a drone camera and crew. This remote-controlled craft was able to go where we couldn't, down the fast-moving waters where Leslie Mueller's body was taken, eventually ending up at this downed tree.
Where'd you put your foot to get to this?
We did some climbing of our own.
He goes up and you can help him up. Yeah.
The steep and rocky terrain was at times a challenge for me and my 48 Hours team.
1, 2, 3, go.
As I approached the cliff where Leslie Mueller's last known photograph was taken,
And she had her arm around the dog.
I tried to imagine her final seconds of life.
According to Fred, Leslie fell from this cliff above me about 20 feet, but somehow didn't land in this rocky area that's about 6 foot wide. Instead, she somehow landed out on this boulder and was swept away.
With all its twists and turns, Cottonwood
Okay,
Creek,
so that
like
gives
this
you,
story, left
some
us with more
background
questions
information.
than answers.
So that the example of the opening statement that I'm going to show you should make some more sense now that you have some context.
On May 3rd, 2008, in Hinsdale County, two people went for a walk up along this beautiful place called Cottonwood Creek. One person came back from that walk, and one person did not. Fred Mueller said his wife fell off a 20-foot cliff, landing on her head onto rocks, hard granite, and from there, she crumpled and oozed into the creek and simply disappeared. Leslie Mueller did not die from falling off a cliff. Leslie Mueller did not die because she got taken by a creek. When Leslie Mueller was taken out of that creek, she had no injuries of any significance. She was drowned. She was found with her head under a log. By all appearances, Fred and Leslie Mueller were a happy couple. Leslie Mueller is a woman who, in the last years of her life, became very devout to her faith. Christian faith, Catholicism. The defendant told the agent from the Colorado Bureau of Investigation that, yeah, he had a wandering eye, but he didn't act on it. The defendant put her head under the water, under a log, and left her there to die. And the defendant is guilty of murder in the second degree. They did CPR for 20 minutes. She was not bleeding. She did not have an ounce of blood coming from her. Leslie Muller was dead because the defendant drowned her in that creek, not because she fell off a cliff. And he told a story that made absolutely no sense. And his story never really wavered. Most of the time, it was word for word. That his wife fell off this cliff 20 feet and landed on her face, her head, her shoulders. The story that he told could not be true. It cannot be true. You will see no sign down there that anyone fell off that cliff. You won't see a single disturbance, and you're going to know that Leslie's body did not end up under that log by natural causes. She was drowned by someone.
Okay, so you
And
can
that
see
someone
a couple
is
of
the man in
things
court,
that
the defendant,
was happening
Fred Muller.
in that opening statement from the prosecution. It was cut off and edited together, spliced together. That wasn't the complete opening statement. But your opening statement for this mock trial could be about that length, say 5 minutes or so. But the prosecutor was laying out the facts as the prosecution is going to portray them, and also told the jury what they were going to show. The evidence will show that she didn't have any bruises on her. The evidence is going to show that she didn't fall. The defendant, right? Calling that guy the defendant there, dehumanizing the defendant. The defendant put her head underneath that log and drowned her, right? And the prosecution also started to try to humanize and build sympathy for the victim by describing, the final moments of her life, or what that must have been like, right? And also by talking about how she became much more religious shortly before, or in recent years, before she died. She had a new found faith in Catholicism, right? So all ways to try to humanize the victim, get the jury to sympathize with her, outline the basic case that they're going to make, that what they're going to show is that this defendant, killed her, and also we see an attempt to try to dehumanize the defendant a bit, right? Let's hear the defense's opening statement.
What the prosecution asks you to believe is that Fred Muller went from this to a homicidal maniac within seconds. A homicidal maniac who drowned his wife in Cottonwood Creek. There will be no evidence of why he would do something so awful. No evidence of any financial reason. In fact, all of her assets had been placed into trust for their 3 children. You will not have any evidence of another woman in Fred's life. There will be no evidence of another man in Leslie's life. They will not bring you any evidence that Leslie Muller was assaulted You will not hear a single breath of testimony of any violence in that home. None. You will hear that he was a peaceful, loving man. On May 3rd, 2008, a Saturday, Leslie and Fred Muller each had a glass of wine and decided to go for a hike before dinner. Fred and Leslie and the dog Gracie got into their Jeep and drove for the hike. First, Leslie takes this picture of Fred, and then they switch. As Leslie Muller begins to stand from this crouch, the already skittish border collie is spooked. Leslie Muller loses her balance and falls. Below that ledge is Cottonwood Creek. The water was fast and very cold. Fred Muller left to go for help as quickly as he could. The 911 call is placed. Over the next 2 days, Fred Muller is repeatedly asked to describe the events, which he does so. Describes them to law enforcement, and he walks them through the events as he describes them. There's no evidence that Leslie Muller was rendered incapacitated. Leslie Muller did not have any significant facial or shoulder injuries. Therefore, they claim his description of the fall can't be accurate, so he drowned her. That's their case. What the evidence in this case will show is that on May 3rd, 2008, a horrible and tragic accident took the life of Leslie Denise Muller.
Okay, so hopefully you identified some of the...
They will not prove otherwise.
Things that we spoke about in terms of what the defense should include in their opening statement. She did a pretty good job in casting doubt in terms of letting the jury know what the prosecution is not going to be able to show, right? So not only did she outline her side, or the defense's side, right? What they're going to claim is that this was an accident, a horrible accident. The dog got spooked by something and bumped into the woman and she fell. So they're outlining their story, right? And she was also on several points pointing out what the defense is not going, or what the prosecution is not going to be able to show, right? They don't have evidence to prove this. They are not going to give you a reason as to why he would kill his wife, right? They're not going to be able to prove this or that. So she did a really good job in terms of priming the jury, letting the jury know, like, be aware that they're not going to be able to do these things or show you these things, right? And in fact, what the evidence is going to show is the opposite of that. And the evidence will show the opposite of that because she's going to try to spin the evidence in such a way to show the opposite of that. So again, the goal here is to try to prime the jurors into accepting your side of the story, right? Okay, so the next time that we meet, or for the next video rather, we'll talk about rules of evidence, but we'll probably just get into direct and cross-examination. Okay, so look for direct and cross-examination on the next video. I'll see you then.